Welcome to this lecture on general exception, that is general defenses. Today in this lecture, we will discuss the laws relating to insanity that provides a good defense to exonerate an accused person from criminal responsibility. Friends, we know that chapter 3rd of the Bharatiya Nyaya Samhita 2023 deals with the various general defenses which a person accused of an offense under the Samhita or any special or local law can plead. This chapter is important from the point of view of criminal responsibility because section contained in it control all other sections defining offenses. These defenses have been put together in one chapter in order to obviate the necessity of repeating in every penal clause. Every definition of offense, every penal provision and every illustrations of a definition of penal provision shall be construed subject to the provision contained in this chapter. Principles enunciated in chapter 3 are in fact the rule of evidence carrying either conclusive or rebuttable presumption. They deal with the circumstances which preclude the existence of mens rea. They are therefore enumeration of the circumstances that are incompatible with the existence of mens rea. If the existence of facts or circumstances bringing the case within any of the exception is proved, it negates the existence of mens rea necessary to constitute the offense and thereby furnishes a ground of exemption from criminal liability. Today, in this lecture, we will discuss one of that very defense, that is the defense of insanity, and we will see that in defense of necessity, how a person, the accused person, do not have the mens rea and essential to constitute the offense. And we will see that under what circumstances what constitute the insanity and under what circumstances insanity will be a defense from a criminal responsibility and will exonerate the accused person from all sort of the criminal responsibility. Section 22 of the Bharatiya Nyaya Samhita, that deals with the laws of insanity and that corresponds section 84 of the Indian Penal Code. This section 22 of Bharatiya Nyaya Samhita provides or runs as act of a person of unsound mind. It says nothing is an offense which is done by a person who at the time of doing it. Very important thing that this insanity must exist at the time of doing it by reason of unsoundness of mind, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Insanity is simply a defect of reason from a disease of mind. The general principle is in order to hold a person legally responsible for a crime, generally speaking, a criminal intent is necessary, and therefore capacity of the wrongdoer to form a criminal intent is a relevant consideration in determining the criminal responsibility of that person. A person may lack sufficient mental capacity to form a criminal intent because of immaturity of age or because of some defects of the mental faculty. When such defect is caused by some disease of mind, a person is said to be insane. Therefore, those who are under a natural disability of distinguishing between good and evil is as infant under the age of discretion, idiots and lunatic are not punishable by any criminal prosecution whatsoever. Stephen, in his digest of criminal law states, no act is a crime if the person who does it is at the same time when it is done prevented either defective mental power or by any disease affecting mental power or by any disease affecting his mind. That is one, from the knowledge, the nature and the quality of the act, or B, from knowledge that the act is wrong. The foundation of law of insanity was laid down by the House of Lords in the then McNaughton case. A brief fact of the case is Daniel McNaughton murdered Mr. Drummond, the private secretary of Sir Robert Peel, the then Prime Minister. In mistake for that statesman, Macnaghten was under insane delusion, that is, in false opinion, that Sir Robert Peel had injured him, and mistaking Drummond for Sir Robert Peel, he shot and killed him. The accused pleaded insanity in his defense, and the medical evidence produced showed that he was laboring under a morbid delusion, because of which he lost his power of self-control. The accused was acquitted on the ground of insanity. His acquittal caused the much sensation and because the subject matter and became the subject matter of debate in the House of Lords. The House of Lords therefore referred the matter to a bench of 15 judges who were called upon to lay down the law relating to criminal responsibility. And the judges were asked, the House of Lords therefore referred the matter to a bench of 15 judges who were called upon to lay down the law relating to criminal responsibility in case of lunacy. Some questions were posed to the judges which they were asked to answer. The question and answer were known as Macnaghten rule, which formed the basis of modern law of insanity. In the opinion of Huda, these answers, although they do not amount to judicial decision, have been and are still regarded as authoritative exposition of the law relating to insanity. The following proposition may be drawn from the answer given by the judges. Number one, every man, that is the presumption with reference to a human being, every man is presumed to be sane and possesses sufficient degree of reason to be responsible for his crime, until contrary be proved to the satisfaction of the jury or the court. Second, to establish defense on ground of insanity, it must be clearly shown that at the time of committing the act, the accused was laboring under such a defect of reason from disease of mind that he did not know the nature and the quality of the act he was doing, or that he did not know that what he was doing was wrong. Next, if the accused was conscious that the act was one which he ought not to do, and if that act at the same time contrary to the law of the land, he would be punishable. Fourth, a medical witness who has not seen the accused previous to the trial should not be asked his opinion whether on evidence he thinks that the accused was insane. Fifth answer, where the criminal act is committed by a man under some insane delusion as to the surrounding facts, which conceals from him the true nature of the act he is doing, he will be under the same degree of responsibility as he would have been on the facts as he imagined them to be. Put in other way, the question is, did the accused know the nature and quality of his act? If not, insanity is a defense. Next, if the accused did know the nature and quality of his act, did he know that it was wrong? If not, insanity is a defense. If he knew the nature and quality of his act and knew that it was wrong, was he under an insane delusion in some other respect? If so, he is in the same situation as to responsibility as if the facts had been as he imagined. This is called by the judges a partial delusion. The Indian law on insanity, as contained under section 22 of the Bharatiya Nyaya Sanhita, that correspond to section 84 of the Indian Penal Code, is based on the first two propositions, that is, number one, that every man is presumed to be sane and possesses sufficient degree of reason to be responsible for his crime until contrary be proved to the satisfaction of the jury or the court, and number two, to establish defense on the ground of insanity, it must be clearly shown that at the time of committing the act, the accused was laboring under such a defect of reason from disease of the mind that he did not know the nature and the quality of the act he was doing, or that he did not know that what he was doing was wrong. The section lays down the test of responsibility in cases of alleged unsoundness of mind. Then the essential ingredient of the section 22 of the Bharatiya Nyaya Samhita or section 84 of this Indian Penal Code. That is, the act must be done. The ingredient, there are 4 ingredients that has to be established by the accused person, by the defendant, in order to plead the defense of unsoundness of mind as to exonerate him from the criminal responsibility. The first thing, it has to be established by the accused person that the act must be done by a person of unsound mind. Number 2, such person must be incapable of knowing the nature of the act, or that the act was contrary to law, or that the act was wrong. Such incapacity must be by reason of unsoundness of mind of the offender. And fourth is, such incapacity must exist at the time of doing of the act constituting the offense. It means that if any person is taking the plea that he was of unsound mind, then that unsoundness of mind must exist at the time of committing the act. That is to say, that unsoundness of mind should not exist either prior to or after committing that very offense. Because in many occasions it may be seen that a person after committing a crime, if he become insane or of unsound mind, then that unsoundness of mind will not exonerate him from the criminal responsibility, but that unsoundness of mind must exist at the time when he did the prohibited act. A man who by reason of mental disease is prevented from controlling his own conduct, and a man who is deprived by disease affecting the mind of the power of passing a rational judgment on the moral character of the act he meant to do, is entitled to the benefit of section 22 of the Bharatiya Nyaya Samhita or section 84 of the Indian Penal Code. The accused is not protected if he knew that what he was doing was wrong, even if he did not know that it was contrary to law, or the vice versa. The unsoundness of mind must exist at the time of commission of the offense, and the onus of proving unsoundness of mind is on the accused. But the accused has not to prove affirmatively, beyond any reasonable doubt, that the person was of unsound mind, and that by reason of unsoundness of mind he was incapable of knowing the nature of the act. The law presumes every person of the age of discretion to be sane unless the contrary is proved. Where a lunatic had lucid interval, the law presumes the offense to have been committed during such interval, unless it is proved to have been committed during derangement. It was held in Chaggan versus State that it would be most dangerous to admit a defense of insanity upon the arguments merely derived from the character of the crime. A somewhat queer behavior on the part of the accused preceding the commission of the crime does not establish that the accused would be called non-compos mentis, that is, not sane or in one's right mind. In order to establish legal insanity, it is necessary to prove that the cognitive faculties of the person are such that he does not know what he was doing or what will follow his act. In Re Balagopal, the accused was living very amicably with his wife and behaved in a friendly manner towards her. He murdered her and his son by stabbing them with a knife. No motive could be suggested. The medical opinion was also definite about the accused not being in a position to understand the nature of the act. Therefore, the plea of insanity was upheld by the court. In Phulabai versus State of Maharashtra, another case, the plea of insanity was granted to the accused who was suffering from chronic and incurable illness. In this case, the accused is in an attempt to commit suicide jumped into a well along with her child, resulting in the latter's death. The accused pleaded unsoundness of mind, but the medical evidence to the effect was lacking. The plea of unsoundness of mind was accepted on the ground that the absence of medical evidence did not justify exclusion of common sense. Again, in Sudhir Chand Biswas versus State, it was held that in murder case, insanity to be recognized as an exception to the criminal liability under Section 84 Indian Penal Code or Section 22 of the Bharatiya Nyaya Samhita 2023 must be such as to disable the accused person knowing the nature of the act when he committed the criminal act. If at the time of committing the offense the accused knew the nature of the act, he is guilty of unsoundness of mind means and implies a state of mind in which the accused is incapable of knowing that he is doing any wrong or anything contrary to law, and the burden of proving this is upon the person who takes the plea. Because as and when any person is going to rely on any one of the general defenses which are provided under chapter 3 of this Indian Penal chapter 3 of Bharatiya Nyaya Samhita or under chapter 4 of the Indian Penal Code, then the burden immediately shifts from prosecution to the accused person. So if a person is relying on the defense which is provided under section 22 of the Bharatiya Nyaya Samhita, the burden shifts from the prosecution to the very accused person. Mere strange behavior of the accused is not enough to constitute his unsoundness of mind. Moreover, it is only legal insanity that furnishes ground for exemption from criminal liability. In order to constitute legal insanity, the unsoundness of mind must be such as to make the offender incapable of knowing the nature of the act or that he is doing any act contrary to law. It is precisely that state of mind at the time of offense, neither ante nor post offense, which is only material for the purpose of determining whether the accused was of unsound mind. Insanity must exist at the time of commission of offense. Section 22 of the Bharatiya Nyaya Samhita 2023 lays down the legal test of responsibility as distinguished from the medical test. There is a clear distinction between medical insanity and legal insanity. And what is a defense under section 22 of this Bharatiya Nyaya Samhita 2023 is legal insanity and not of medical insanity. And the courts are concerned with the legal and not with the medical view. For example, a man may be suffering from some sort of insanity in the sense in which the expression is used by a medical man, but may not be suffering from unsoundness of mind as contemplated by law. Mere unsoundness of mind is not sufficient to bring the case within the exception. It must also be proved that the accused was, in consequence, incapable of knowing the nature of his act or what he was doing was wrong or contrary to law. Person of unsound mind. There are four kinds of persons who may be said to be not of sound mind, that is non-compos mentis. Number one, an idiot. Number two, a lunatic or a madman. Number three, one made non-compos mentis by illness. And number four, one who is drunk, that is non-compos mentis. The accused must first of all show that he was suffering from a disease of the mind when he did the prohibited act. Number two, the accused must show that he was suffering from a defect of reason due to disease of the mind that completely deprived him of the reasoning power. That is, the disease of mind must affect his reasoning power to such an extent that it renders him insane for medical purposes. The defect of reason so caused must affect the legal responsibility. That is, it must affect a person's capacity to appreciate that he was doing and whether it was lawful. That is, it must affect his capacity to know the nature of the act or distinguish between right and wrong. Fourth, the defect of reason from disease of the mind must exist at the time of the commission of the offense. Then what is who is idiot? A person who is of non-sane memory from his birth by a perpetual infirmity without lucid interval is said to be an idiot. Idiot is also one who cannot count 20 or tell the day of the week, or who does not know his father or mother or the like. A lunatic is a person who is affected by mental disorder only at certain periods and vicissitudes having interval of reason. But madness is permanent. Lunacy and madness are said to be acquired insanity and idiocy by natural insanity. Non-compos mentis, a person made non-compos mentis by illness, is exempted from criminal liability in case of such acts which are committed while under the influence of his mental disorder. Unsoundness of mind. The word unsoundness of mind has not been defined in the Bharatiya Nyaya Samhita. To Stephen, it is equivalent to insanity. Insanity means a state of mind in which one or more functions of feeling, knowing, emotion, and willing is performed in an abnormal manner, or is not performed at all by reason of some disease of the brain or the nervous system. Insanity includes lunacy, mental derangement, mental disorder, madness, and so on. The expression unsoundness of mind as used in this section is wide enough to include all varieties of want of capacity, whether temporary or permanent, natural or supervening, whether it arises from disease or exists from the time of birth. There are numerous degrees of insanity. In order to be an excuse, insanity must reach that degree which is described in the latter part of the section 22 of the Bharatiya Nyaya Samhita. If a person is found of unsound mind, his liability for an offense is determined by the ordinary rules in regard to insanity. It does not matter whether the insanity arose from disease of the brain or from the persistent indulgence in intoxicating drug or liquor. Insanity brought on by drunkenness. Drunkenness is no excuse, but delirium tremens, severe alcohol withdrawal symptoms such as shaking, confusion, and hallucination. Delirium tremens is a permanent change in the brain tissue which renders a person incapable of knowing the nature of the act or what he is doing is either wrong or contrary to law, that renders him next to of unsound mind. That these symptoms caused by drinking from drunkenness. If it produces such a degree of madness, even for a time, as to render a person incapable of distinguishing right from wrong, afforded a ground of excuse from criminal responsibility. Insanity created by habitual drunkenness, whether it is permanent or intermittent, is the same as insanity produced by any other cause, and the act is exempt from liability. At the time of doing the act, the requirement of section 22, a person can get the defense of insanity only when he is of unsound mind when he did the prohibited act. That is, at the time of doing the act, he must be of unsound mind. To say insanity must be proved to exist at the time of committing the act constituting the offense complained of. A plea of insanity at the time of trial will not help the accused. If at the time of commission of the crime a man is found to be laboring under such a defect of reason as not to know the nature of the act he was doing, or that, even if he knew it, he did not know it was either wrong or contrary to law, then this section applies. In coming to that conclusion, the relevant circumstances, like the behavior of the accused before the commission of the offense and his behavior after the commission of the offense, should be taken into consideration. In order to see whether the accused was insane at the time of commission of the offense, the state of his mind before and after the commission of the offense is relevant. Legal insanity. In Someshwar Bora versus State of Assam, the accused left the place of murder immediately after committing murder. And remember clearly, in a confession given on the very next day, what he did, it was held that the accused was not entitled to protection of Section 84 of the Indian Penal Code or Section 22 of the Bharatiya Nyaya Samhita 2023, as it could not be said that he did not know either the nature and quality of the act, or that he did not know that what he was doing was wrong. The fact that he had some sort of abnormality and mental imbalance was immaterial. Then, after incapable of knowing the nature of the act, etc., the McNaughton rules declare that if the accused was conscious that the act was one which he ought not to do, and if the act was at the same time contrary to the law of the land, he is punishable. A man is said to be ignorant of the nature of the act when he is ignorant of the properties and operation of the external agencies which he brings into play. For defense under this section, there must be incapacity to realize the nature of the act. The Bharatiya Nyaya Samhita uses the words nature of the act as opposed to nature and quality of the act used in McNaughton's rule. A person is ignorant of the quality of his act if he knows the result which will follow, but is incapable of appreciating the elementary principle which make up the heinous and shocking nature of the result. The word quality of the act do not refer to its moral aspect, but they deal only with the physical character of the act. The word quality of the act are not used in the Bharatiya Nyaya Samhita. The offender may under the Samhita be incapable of knowing that he is doing what is either wrong or contrary to law. The word wrong here means physical wrong. It does not mean an act which is normally wrong or morally wrong. Similarly, in McNaughton's rule, the word wrong has been construed to mean contrary to law and not wrong according to the opinion of man. Insanity, in order to be a defense, must be such as to disable an accused person from knowing the nature and the consequences of his act at the time of the commission of the offense. If it were not so, the responsibility cannot be absolved. The correctness of the sentence in such a case cannot be questioned by the Supreme Court, and the court cannot re-examine the fact once the matter has been rejected by the President of India in capital offences. We have to see the difference between medical and legal insanity. Medical insanity and legal insanity, that is unsoundness of mind, are different from each other. Medical insanity is solely dependent on medical grounds, while legal insanity depends on the factors required to be proved in a court of law to enable the accused to be acquitted of the charge. In other words, legal insanity furnishes a good ground of defense from criminal liability, while medical insanity does not. In order to establish legal insanity, the necessary element as provided by Section 22 of the Bharatiya Nyaya Samhita must be proved. If there are sufficient medical grounds to hold that a person is suffering from insanity, it is a case of medical insanity. In other words, the existence of medical insanity is to be proved with the help of medical evidence. Legal insanity, that is unsoundness of mind, for the purpose of section 22 of the Bharatiya Nyaya Sanhita 2023 means that the defense must prove that at the time of commission of the crime with which the accused is charged, because of unsoundness of mind, he did not know the nature of his act or that he was doing what was either wrong or contrary to law. The incapacity of the accused must be caused by some disease of the mind and must exist at the time of commission of crime. Medically, a person may be certified sane or insane as the case may be, but legally he will be held insane of unsound mind only if he successfully proves the requirement of the law laid down under section 22 of the Bharatiya Nyaya Sanhita 2023, which will entitle him to be acquitted of the charge. If he fails to prove that the law presumes him sane at the time of commission of the crime by him, even though medically he may have been insane at that time. A Durham rule. In Durham versus United States, Durham was charged of housebreaking and he pleaded insanity in his defense. The Circuit Court of Appeals declared that the existing tests of criminal responsibility are obsolete and should be superseded. The existing tests included both the McNaughton rule and the irresistible impulse test. In this case, the court evolved a new test, namely simply that an accused is not criminally responsible if his unlawful act was the product of mental disease or mental defect. Mental disease and mental defect were defined only because the accused was suffering from a mental disease or mental defect at the time he committed the act in issue would not suffice. He would still be responsible for his unlawful act if there was no causal connection between such mental abnormality and the act. If it was proved that the offender was suffering from such mental abnormality, the burden will then lie upon the prosecution to prove beyond reasonable doubt that the act was not the product of such abnormality. The two tests, McNaughton rule and the irresistible impulse test, could still be employed, and the Durham rule was in addition to those tests. Thus, the Durham product test means the simple fact that a person has a mental disease or defect is not enough to relieve him of responsibility for a crime. There must be a relationship between the disease and the criminal act, such that the act would not have been committed if the person had not been suffering from the disease. In simple words, there must be a causal connection between the unsoundness of mind that was caused because of the disease of the mind. It has to be shown that there was a causal connection between the act done and the unsoundness of mind. Simply, the act would not have been done by the accused person had he not been suffering from unsoundness of mind. So, the doing of an act must have a causal connection, must have a source of the unsoundness of mind to say that had he not been of unsound of mind, he would not have committed the prohibited act or committed that criminal act. Lakshman Dagdo case, a very important case. The accused Lakshman was suffering from fever and feeling annoyed with the cries of his children. Accused had fever since 5 days prior to the day of murder, and on that day he had high fever. It was conceived that if the case had to be decided by a medical test, the accused would have to be acquitted. But the question was whether the test was legally applicable. Held. A man may be suffering from insanity as an ailment but may not be unsound mind as expressed under Section 84 of the IPC or Section 22 of the Bharatiya Nyaya Samhita. Thus, the conviction was upheld in the case on the basis of consciousness of the nature of the act. Another case, Attorney General for South Australia versus Brown, the accused in this case, aged about 25 years, murdered the manager of the station, Lord Neville, where he engaged to work as a hand at the station, to whom accused met for the first time when he arrived there. At the trial, admitted that there was no apparent motive in the accused for the murder, and to question as to why he did the act, the accused simply answered, "I could not help myself." Still to a question whether he would have pulled the trigger of the rifle if there had been a policeman by the side, he replied no. The Privy Council rejected the plea of insanity based on uncontrollable impulse. Another important case, Asiruddin versus King Emperor, it was held that of the three elements necessary to establish under Section 84 of the Indian Penal Code or Section 22 of the Bharatiya Nyaya Samhita 2023, any one of which must be established by an accused to obtain the benefit of the provision. The first, the nature of the act was clearly known to the accused in this case. The accused was also know that the act was certainly or contrary to law. The act was contrary to law, but he certainly did not know that the act was wrong. The accused was clearly of unsound mind and acting under the delusion of dream and held entitled to the benefit of Section 22 of the Bharatiya Nyaya Samhita, that is Section 84 of the Indian Penal Code, and the third element was absent. Another case, in Kanbi Kurji Duda versus State of Gujarat, where the accused killed Bhagadi and Karna, it was held that the accused was conscious of the nature of the act. The accused was not on any hostile or uncordial terms with the deceased Jamna and son Natha committed by him, but the accused was not in a position to appreciate and realize that the act committed by him were either wrong or contrary to law, and hence under the circumstances the accused was entitled to the benefit of provision of Section 22 of Bharatiya Nyaya Samhita 2023, that is Section 84 of the Indian Penal Code. Then proof of insanity. The legal position regarding the burden of proof in the contest of the plea of insanity is stated by the Supreme Court in Dayabai Chhagganbhai Thakkar versus State of Gujarat. The prosecution, it was held in that very case, the prosecution must prove beyond reasonable doubt that the accused had committed the offence with the requisite mens rea, and the burden of proving that always rests upon the prosecution from the beginning to the end from the trial. There is a rebuttable presumption that the accused was not insane when he committed the crime in the sense laid down under Section 22 of Bharatiya Nyaya Samhita 2023, Section 84 of the Indian Penal Code. The accused may rebut it by placing before the court all the relevant evidence, oral, documentary, as well as circumstantial. Even if the accused was unable to establish conclusively that he was insane at the time he committed the offence, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regard one or more ingredient of the offence. The court would be entitled to acquit the accused on ground of the general burden resting on the prosecution has not been discharged. Thank you. We'll meet you in the next lecture.